is this what you're introducing? Morning. Hi, how are you?
Good morning.
I guess I just jump right into everything.
Did you have anything you want to go back there, or you already did?
I don't know, I didn't count. I printed it double-sided, so it probably is.
Oh, this is double-sided?
Yeah.
New generation always prints double-sided.
This one is, oh, I guess it's not.
This is that, yes. Then there's the X-ray. This isn't double-sided either. I think this would be bigger.
This is what Danielle sent over.
Let me see, because I think we have them here.
This can't be right, because the admission date's November 25th of 2010.
Yeah.
So this is not his stuff.
Yeah, I feel like it should be like this.
Gunshot wound to right
It should be like this.
Okay, I don't have those.
I feel like it should be like this.
Alright.
And then,
This must be either. I'm sorry?
I'm sorry.
yeah, this is,
This must
164 pages.
Daniel Beltran. Based on the, that one looks like it might be Daniel Beltran based on the location.
Yeah, Daniel TGH, yes.
Oh, there you go, okay.
That's correct.
This is,
And then if this is 36 pages, and this is correct. That's correct.
so then what
And
I'm
then
missing is just the TGH.
TGH and the X-rays, which were about 9 pages. Thought I had it with me. So it's this. I have my dog wasn't around me and I told him.
Story of my life.
It'll take a minute. Okay.
You can find it later, Kim, I just was wanting to make sure what I had. was-
Yeah, those.
So these are
weren't
wrong,
great.
okay.
Let me take my tabs off of this and I'll give you this. And let me see if I can get the X-rays sent to me, Linz. It was just the X-rays taken of the stuff. It's nothing.
I think those may be on a disc that I've got.
Yeah, you
I
should
saw
have
I
them.
had a disc that was labeled X-rays, so I'll take a look at that.
And I'll confirm it when Danielle gets. I think they're capacity exhibits. These are just my copy.
MK X-rays to June, January, copy to
There's that one. Yeah.
September,
There's that one.
April.
Because there
This is
was.
September.
Yeah, there wasn't a
TN
ton.
X-ray, imaging, April.
There was an April. Yeah.
Okay.
It wasn't a ton. There was like 9 or 10.
That looks like.
Let me see if I can find the.
No, I think Danielle does. Or Rick.
You know what? It's in one of these two things. So I think
Yeah,
it's-
they were, she brought them, she said that she's,
Oh, she has them with her.
yeah, Rick
Yeah.
asked her to take them back to the office.
Yeah, Danielle has them with her, so when she comes,
Okay.
that's my personal copy, but I'm pretty sure that's the TGA
Thank you.
No, no. Yeah. Yeah, where you want?
So everyone except the one that texted, I suspect.
as Mr. Navarra, and they both can be back here tomorrow if necessary.
Okay,
So I just wanted to let the court know.
I appreciate that.
We want to have the bailiff reach out, deputy reach out.
Yeah, let's do that too, just to see, because if he says, look, there's no way I'm going to be there tomorrow, then, we're not going to shut it down for
Right.
2 days.
Yeah.
So we might as well, since they're here, and not inconvenience them.
Sure.
So, Deputy Estea, do you mind calling the number and just say that the judge asked for an update about what the possibilities are of him being here tomorrow? He doesn't have to give you details and tell him, but just the possibility. What if he has any idea of the possibility of him being here tomorrow?
On the message, he said, if she gets released.
Right, right. So, and he may not know. He may not have any information, but who knows? All right, we'll wait and hear if we have an update.
Thank you, Judge.
Bring the rest of them in and tell them. I obviously don't want to disclose too many details. I'll just say that juror number 14 has had something come up where he can't be here today, and in an abundance of caution, I don't know how much I want to go to that. I'm sure they know that there are alternates. I never identified the alternates, so I just don't know how much I want to talk about. I'll just say in an abundance of caution, because here's what's going to happen. On Friday, when then we release 3 of them, you were alternates, I say, well, why did, but it's not that big of a deal. All right, so I think the decision is clear at this point that we'll go ahead and do that, which will condense the rest of the trial rather than having multiple half days. We'll have a full day tomorrow, it looks like.
Pretty close, I think.
Kind of close.
Remember, you cannot start at 8.
Well, I can't start at 8:30 tomorrow, but I can start at 9, so that's fine. Yeah.
That would be.
With a 9 o'clock will be good.
Yeah, yeah. So, I don't think it starting early was ever an issue. Now that we're kind of strung out, so we'll start at 9. That's what I'll tell them. I'll tell them just to take the day off. They were here. It's not like
I'm sure they're gonna welcome that.
they have to go back to work or anything. I don't know. That's up to them. I'm not making that decision for them. But let's do that. But what I'd like to do is anything that we can get done, like jury instructions, just, talking about them. If there's any issues, I know that we've given jury instructions in this case once, so it shouldn't be much of an issue. But there were some things we talked about that was going to add. We have to add the Spanish interpreter instruction. I don't know if there's anything else, but if we can just flip through them so that we're in really good shape Thursday. We're going to need to finalize them Thursday, because the plan now is to do closing arguments, instructions and closing arguments first thing Friday morning. So we'll try to utilize some of our time while we're all here today. And then,
Judge, can I release those two witnesses?
yes, you absolutely can. And Mr. Grant, you can call your witness who was driving in.
I'm gonna go print your jury instructions that were sent
Oh,
to
thank you.
yesterday.
Thank you. That means it's going to take longer. What I'll tell them is that based on the schedules of some of the remaining witnesses, it was going to be kind of strung out, so this will consolidate it for Wednesday, Thursday, and Friday. It's not going to delay. I don't want them to be concerned that it's going to delay it by taking the day off.
Yeah, because we've worked to consolidate, and we should be in great shape with time.
Judge, you're going to make it clear to the jury that we're doing this because the juror is absent.
Yes.
Right? Okay.
Yes. Yes. That's what I'm going to start with.
Okay.
Hold on a minute. Let me just make sure everybody's here. Yeah, I guess you can line them up. Yes, we are.
All right, jurors entering.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good morning and welcome. I have some things to discuss with you this morning. You may notice that juror number 14, who sits in number 14, is not here this morning. I do not want you to be concerned about him. He is fine. he has had a family issue, a family emergency, and he cannot be here with us today. However, in talking to him, it appears that he can most probably be here tomorrow. So in talking to the attorneys about the schedule for the rest of the week, it has become obvious that we were going to have some downtime over the next couple of days based on the availability of some of the future witnesses over the next couple of days. So I've made a decision to consolidate the rest of the week, and we're going to take today off so that juror number 14 can most likely join us again tomorrow. So I'm giving you the rest of the day off. So you can talk to your union rep about that, giving you the day off. Shouldn't be a problem. It is very important. Well, first of all, I don't want you to be concerned that that throws off our schedule. We absolutely will still get this case to the jury on Friday, and you will begin deliberating on Friday. There's no question about that. So I don't want you to be concerned about that. It is also still important that you not discuss this case amongst yourselves or with anyone else, that you not do any research related to this case, and that you not watch any reports about this case outside of the courtroom. There's no reason, well, I will, in abundance of caution, ask, did anybody discuss anything about this case between the time you left yesterday and the time you returned today, or was anybody exposed to anything about this case between the time you left yesterday and the time you returned this morning by show of hands? Excellent. Let the record reflect that there are no hands. I apologize to you for driving down here and me telling you that we're not going to have court today, but it's just in an abundance of caution so that we have everyone with us for the rest of the trial. So that's why we've made that decision, and it was only made after consulting with the attorneys and being assured that it's not going to set us back by taking today off. It's actually going to stop us having a half day here and a half day there by consolidating that downtime into today. So I'm going to release you. We're not going to call your employers and tell them that you weren't here all day, so that's entirely up to you. You were here. You were on jury service today. So what you do with the rest of the day is entirely up to you. Unfortunately, it's very cold outside. I don't understand this temperature. It's not supposed to be like that in Tampa, Florida at this time of year. But I again thank you very much for your important service, your patience with us, and all of you being here. We will see you tomorrow morning. We're not going to start early. We're going to start at 9 tomorrow. So shouldn't be a problem for anyone. And with that said, I'm going to go ahead and release you for the day. All rise for the jury. Jury has exited. Everyone may be seated. Well, I think that went well as could be expected. Some of them seemed excited about it, especially when I told them I wasn't going to call their employer and tell them that we released them early. All right, so what can we do? You want some time?
Judge, I know that there are still a couple of matters I think that we can handle. I know that there was a ruling on, there was a pending ruling on that vigilante justice issue that I think Ms. Johnson is going to handle for us that has still not been addressed.
Right. And we can do that, absolutely.
And I intend on introducing the text messages of the defendant. I don't think that there is any, they're not going to ask me to bring in the record custodian. We have laid a predicate, but I think they may have an objection as to relevance, so I think that's something maybe that can be argued and handled this morning, if defense is ready for that.
I can do that.
Judge, there also was the matter of, there were 2 photographs of handcuffs that we had identified by the crime scene investigator, but there was some reference that was found by the defense of we not introducing it the last time. Based on a prior ruling, we have not been able to figure out what that motion in limine or ruling was, so we wanted to address that.
This is regarding pictures of handcuffs?
There were 2 photographs of a handcuff and I believe a flashlight that was found in the Keetley house. Correct. So we wanted to address that as well.
Okay, you can do that. And I'd also like, we received proposed jury instructions last night with the addition of 2.12, jury to be guided by official English translation, interpretation, closing instruction. Did the defense receive that?
Judge, I know we received it, but to be honest with you, we were working on our witnesses and meeting with our witnesses last night, and so that was been our focus. So the jury instructions, I can make sure that we start doing that tonight or do it today because we have a full day, and maybe we can discuss them tomorrow.
All right, there shouldn't be a lot of issues, I don't imagine. I mean, it's the exact same charges. So, the substantive instructions regarding the charges, I don't see why there would be any change. And then the others are pretty much standard instructions regarding, there's always, as I said, we'd wait till the appropriate time to see if Mr. Keetley intends to testify or not. That could change an instruction, but that's a simple either take something out or add something into another instruction regarding that.
Judge, I agree with you. I think that the fact that there were instructions at the last trial with the respect that we have for Judge Gowdy and when she was trying this case, I'm sure that they are in great order. And so we just have to look at them and see.
All right. Then we don't need to go over those today. I have no doubt. I'll allow you all to do that, but I want you to use some of this time today to go ahead and look at them and communicate with the other side if you have any issues so that they can take a look at them or they can be prepared. But I never foresaw any issues with the jury instructions. The verdict is quite lengthy, so go ahead and take a look at that, but that's because there are multiple counts. Take a look at the verdict and see if you agree with the form of the verdict, and if not, let them know what your disagreements are so that we can kind of narrow any jury issues. But I think we'll have time on Thursday, it sounds like, to address that. All right, well, let's address those other things. Is the defense ready? You said you were on the text messages. What about the vigilante? Was that in opening statement?
No, Judge, that came out through the testimony of Stacey Rogan. She didn't use that term, which I believe that's what your order had stated.
Right.
I have a copy of her testimony, part of that testimony, and then a copy of the order from what you stated, or a copy of the hearing and what you ruled in court regarding that.
Right.
So I think that your ruling was that term could not be utilized. Ms. Rogan did not use that term, even though that was the term the defendant used when she was speaking with him. She stated that it was, that he understood why people would take things into their own hands. And
Let me just see the part where the objection was made, her testimony, where the objection was raised. And I'll give the defense an opportunity to be heard on it. And if you need to look at this, I just want to refresh my memory as to her testimony. And I will note that there's been several other witnesses who have testified regarding that theme, not that word of vigilante justice, but that theme of revenge, I think, has come out from multiple witnesses since this witness testified. Ms. Johnson, this is not the whole testimony, is it? No. It's just an excerpt?
It's just the excerpt of where the witness's statement from the trial judge. That's what was asked of the court reporter.
I don't see where an objection, though, is raised. Am I overlooking it?
They did not object because they didn't want to draw attention to it.
Oh, so they
brought it up.
approached afterwards
Yes.
and argued. Well, is there any additional, let me, it's only a couple pages, so I'm going to read the whole testimony. Okay, did the defense have the benefit of this excerpt? I think that it does accurately have the part. It's actually towards the end on page 4 of the transcript, starting at line 16, is what I believe is what was ultimately objected to by the defense.
Correct.
I think that was it. The answer to your question is I think we do. I just didn't have it pulled up in my email.
Well, go ahead and check, or with that, do you have any additional argument?
Yes, if I may, and sorry, I'm going to sit down if that's okay.
That's fine.
Judge, I'd like to refer you back to the motion that I filed in this case, because it wasn't just the actual term. We had a lot of discussion about this, and in fact, the state's first position was you made an oral ruling, so we were in compliance with the oral ruling of the court. Actually, what you did at the motion of this matter is you reserved ruling and then made a written order. I'll refer to that in just a second. You asked me at that hearing, when we were talking factually, I can't recall precisely, but I think you asked if this fact is admissible, if this fact is admissible, is this fact admissible, why can't they do that? And my response to you was, I cannot prevent the prosecution from pushing their theory of prosecution to a jury, but they have to do it with admissible evidence. And I distinguished what you were presenting to me as these issues that you bring up, maybe in conjunction, could be admissible on their own, and we will deal with them. But this, the term vigilante justice, and that testimony is not admissible. Here's, if you recall, we had two things going in that motion. Number one, we had Norma Towers and the Charles Bronson death wish. She liked Charles Bronson. He says something more affirmatively, if we're going to believe Norma Towers, about vigilante justice. With Stacey Rogan referring to my motion, her statement was rather benign. It was something about vigilante justice, and he said, I understand vigilante justice. It wasn't a pro statement. It was not a negative statement. It was just a statement. I understand. Okay? What the prosecutor did, without approaching the bench, is they've now taken the position, well, we didn't say the word vigilante justice. And actually what happened was, this testimony went further. Referring to page 4, line 16, did he, Mr. Keetley, make any statements to you regarding handling things himself or taking this investigation into his own hands? Answer, not those exact words, but he was actively looking for the people that had shot him. Question, did he make any statements about thinking that he understands how people take things into their own hands and matters into their own hands. Answer, oh yes. We could not impeach on that statement because we would then be bringing in the concept of vigilante justice. What the prosecutor did was go further than Stacey Rogan has ever testified before. And it wasn't when you put in your written order the concept of vigilante justice, and I'm sorry, the order I think also says Charles Bronson or death wish. You put those two things into quotes, not to indicate, from what we understood, not to indicate you can't mention Charles Bronson, you can't mention death wish. Notice that they went nowhere near that with Norma Towers, right? But with Stacey Rogan, they brought in testimony plus. They just changed the words and made sure we could not impeach on it. So it absolutely, totally, completely violates your ruling in this case and really left us in a position where we could do nothing about it because they just changed the word. If they had an idea that they could bring in this testimony and just not use the term vigilante justice, the prudent and proper thing would have been, hey, we want to approach the bench and we want to get a clarification on this because we're going to bring in that testimony. We're just not going to call it vigilante justice. Because if you look at my motion, I tracked the language of Stacey Rogan. And one of the things we did at that motion hearing is we read, and the court heard what was the question and answer in relation to her testimony. And then they did the exact same thing, went further, and just left us in a position that we essentially have to eat it. Because if we impeach her on it, as we have repeatedly impeached witness after witness after witness, guess what? We bring vigilante justice in. So it is a violation of the motion.
So it's not that he was actively looking for people. That's not the issue. It's that he understands how people take things into their own hands. That's the statement.
Yes, but she didn't ever testify. That's the plus. The first part that you say is not the issue. That's the plus part. That's the addition. That
actively looking.
Mm-hmm. Yes, sir. Right. That's the. It's put that all in conjunction. So if we wanted to negatively impeach on that or say that's not quite what you said before, guess what we're doing? Question, answer, vigilante justice, boom, and now we bring it out. Not because we have opened the door, but because the prosecution has forced open a door and left us in a quandary.
So that was indirect. You had the opportunity to cross-examine, and your position is that you didn't touch that on cross because you were afraid of opening the door of the specific words of Bronson and vigilante justice?
I'll answer first directly. I'm not caring at all about Bronson, because Charles Bronson death wish, that dealt with a totally separate witness. Secondly, not a big issue, but I wouldn't describe us as being afraid of that particular testimony so much as the concern is to impeach her and put her in her accurate testimony may have in fact, yes, opened the door to vigilante justice where the court had kept it out. It was not simply you can talk about it, just don't do those words.
Well, tell me then, remind me why the fact that she can testify that he made a statement regarding understanding how people take things into their own hands is not admissible.
Well, one, she's never said that before. It was in the conjunction with the testimony.
No, she said vigilante justice. Now she's rephrased it this way, but I understand the term vigilante justice, which was what my ruling was that they couldn't use, how that might be, I don't know, taken prejudicial, but her explanation of that he expressed that he understood how people took things into their own hands. Why is that not admissible? What if those were her words instead of vigilante justice? What if she simply said that the first time?
So I'll respond in this way. First, those weren't her words, but I understand the question.
No, her words were vigilante justice, which you moved to keep out.
But no, it's more than that. It wasn't a I understand vigilante. It was he understands. The testimony in that regard was benign. It wasn't what it is. It was he understands. Period. So that was the issue that we
He
asked to keep
understands
out.
vigilante justice.
Correct. He understands. In fact, sorry, I went to my remote screen, pulling up the motion again on my regular screen here. The testimony that she gave, former girlfriend, during her testimony, she made a general reference at some point at an unstated time, the phrase vigilante justice in a discussion. It came up, and he said something to the effect of he understood why that existed. It was a general statement. What you're suggesting in your hypothetical to me is, what if he said, I understand why people want to take things in their own hands. That was put before this jury that Michael Keetley supported vigilante justice. The statement that we limited out was he understood why it existed. He didn't say he was for it. He did not say he was against it. The statement came up in some conversation that she cannot recall, at some time that she cannot recall, in some context that she cannot give, which is he just said, I understand vigilante justice. Judge, I understand vigilante justice. That statement is not pro. That statement is not con to vigilante justice. He just said he understood it. The witness then decided, with the direction of the prosecutor, to not use the phrase vigilante justice, and then said, did he make statements about thinking that he understands how people take things into their own hands and matters into their own hands? Oh yes, in conjunction with, I am actively looking for them. So they made it seem like his vigilante justice statement, which was just not named vigilante justice, he was in favor of it. Okay? So how do I impeach on that? I think at this point in time, you've seen from Ms. Kolev and Ms. Khan and Mr. Escobar and myself, we're not afraid to confront and cross-examine witnesses, and maybe even half effectively at times. The point is, how do I confront on that? Because you gave an order that said, don't do it, and then they did. They just didn't use the specific or technical phrase.
That's not the argument that you made when you approached about before you had done your cross, that you weren't going to be able to do that. You came up, I believe, before you did the cross, and the objection was that she was still testifying to the same theme of vigilante justice, and that the order went beyond simply the term, but included limitation as to the theme. But there was no discussion about not being able to cross on certain things. I mean, the argument seems to have developed now.
So you say you, and I'm trying to remember back.
No, it wasn't you. It was Mr. Escobar.
No. I'm not.
And I think that might have been when multiple people were allowed to approach.
That's why I'm trying to remember whether I was at the bench or whether it was Ms. Kolev or Mr. Escobar or whatever combination. As I stand here today, I don't recall being a part of that conversation. However, whatever that conversation was, that's entirely consistent with our objection. I don't think there's anything in the evidence code that says, I object and here's the effect. A lot of times we make that argument. Judge, if you let a police shirt in when everybody's saying sheriff, this is a problem. We've argued that for days and days and days in front of you. In this case, I don't know what was said at the bench, but I would argue if it's been developed by both sides, because now we have the advantage of the transcript. Remember, the state's position at that time was, we're in line with an oral ruling that you made. And we said, no, there's a written order in this play. So they, in doing what they did, without treading carefully, without saying, Judge, here's where we're going. We know there's a written motion in limine. How many times have we had conversation? There's a motion in limine on that. You're not going to go here. You're not going to go there. Well, in this case, the state deliberately and willfully drove through an area where there was a motion in limine in place.
Well, that's your position. Let me ask you this. If, and I'm not suggesting I am, but if I was to find that it was a violation of the motion in limine What do you want? You want a mistrial?
Yeah, well, that's $1 million question. I would say yes, only if I knew, he's looking at me, only if we knew that there would be prosecutorial misconduct attached to that. And even though I believe what they did was wrong and not the correct answer in that case, I don't know that it rises to that level. You're shaking your head no, so the answer is clearly no. We do not want a mistrial, all right? So that would be the only way that I would ask for a mistrial if I knew that would finally put it into this 12 and a half.
That's smart. That's smart.
All right? So,
On your part.
given that you're not giving me that green light, that's kind of, quite frankly, $1 million question that we've talked about, because it's a problem when the other side does not respect your ruling, and we cannot handle it without making something worse based on a transcript and a testimony. So we thought about an instruction to the jury. We thought about, at a minimum, preventing the state from arguing that piece of evidence in their closing argument.
Let me see, Ms. Johnson, can you hand me you said you pulled the order, is that correct? I probably have it up here, but I think you had it in your hand, the exact order that addressed vigilante justice, the
Judge,
written
I
order.
have a copy of the hearing, but I have.
Oh, you don't have the order?
Judge, may I approach?
I do, I can
If I may approach, I've got the order.
Yeah, you can. Like I said, it's in a stack here, but if somebody has it at their fingertips, you can find it.
Yes, if
Vigilante, I thought they were
if she's
here.
thumbing,
Oh, they're kind of spread out.
I'm just showing you the headline, because you ruled on 2 or 3
Right.
motions at the time. Let's see if I can scroll. I think it's on the 4th. Oh, boy. I think I just...
Anything else from the defense?
Not unless you have a direct question for me.
No, I've read it, and I recall, and I've now read the transcript of the objected to testimony, and I'm going to make a finding that it does not violate the motion in limine.
Gotcha.
All right.
Your Honor, it's going to seem like I'm jumping to another issue, but
That's fine.
real quick. I think
We got all day.
We got a lot of time. I think yesterday, or 2 days ago, it may have been with Mr. Lugo on the stand. We talked to Michelle Doherty about this. At some point in time, Detective Lugo testified about 2 trash bags, or that there were trash bags, and he would have liked to have seen what's in them, those types of things.
Was this on cross?
I think maybe on redirect it came out. I'm not sure at that time whether we preserved that issue. As the court may recall, I did file a motion in limine that was heard by this court, that there's no indication of what was in the trash bags, nothing.
Are these the trash bags when the van was painted?
At Bo's house, yes, Henry Bo's house. You denied that motion. And I don't know if we made the objection.
Oh.
I'm making sure, I know we've had some conversation a long time. I'm not re-arguing it.
You just want to make sure it's preserved.
Correct. All of that has been extensively argued, I believe.
Yeah.
If we didn't make the objection, we chose not to, of course, highlight it. The court has during the course of testimony at times said, hey, since we have a definitive ruling, we consider it preserved.
Well, and that's what the rule says, so that's what, but I don't mind you, as we've done throughout, kind of outside of the presence of the jury, you preserving it to make sure that it's preserved.
Right.
So I'll allow that. If you didn't do it previously, I'll allow this to preserve it, although I think that the rule says once it's definitively ruled on, it's preserved.
Correct, and I think that's what we were operating by, but again, just make sure we have a record that when we have the advantage of talking to you all day without a jury, that has in fact been preserved.
All right, that's not a problem. I'll allow that. How about the text messages? Does somebody have an exhibit
I
of
do,
the
Judge.
text messages?
I do. Judge, and I do note that they, I believe defense had a exhibit, but they did not introduce them, but it was marked for identification when they were cross-examining Norma Towers. Connie Bell had testified that she did do a download of the phone, and when Lieutenant Lugo was testifying, he had specifically said that he got a search warrant for the incoming, outcoming calls, and he had never done a search warrant for the text messages, but there was another source for the text messages, specifically being the phone download. There was a download that was done, and it covers the time frame from November 6th of 2010 through December 1st of 2010, and specifically the time frame of the homicide, there were no text messages. There is nothing between November 24th of 2010 at 9:54 p.m. and November 25th of 2010 at 4:06 p.m. So again, there is a huge gap of phone activity so we did not do mapping in this case. That was brought out through cross-examination that Detective Lugo at the time did not ever do a search warrant from the phone company for the text messages. Obviously on redirect we redirected him about that there were text messaging that was covered from the download of the phone. So we believe that that is relevant. He testified that he did not do mapping in this case because there was no information that would have covered the crime, the period of the crime, anywhere from after 2 o'clock to 2:30. There is nothing there. Even the time immediately preceding that, which would have been traveling, all of that, including on the incoming and outcoming, there wasn't a call until after 10 o'clock, and then it went to 7 o'clock the next day on November 25th, and that is the same for the text messages. So they are highly relevant in this particular case. So I'm not going to have any further testimony on it, but
Who do you intend to introduce these through?
Judge, we had already had them. I think they're stipulated by both parties that they're not making me recall Connie Bell. That I think, correct me if I'm wrong, they have an objection as to relevance.
Well, but these aren't just between the defendant and Connie Bell. There's multiple
Not
phone
Connie
numbers.
Bell, Norma. Correct, Judge. They are, but it shows there was some questioning of Detective Lugo by Mr. Escobar about a supposed 2:30 text message from a Lori Mathis that he called. So there's that's the only thing that we want to get in, is the fact that there were no text messages for us to be able to do any mapping close in time to the crime. I understand there are additional text messages, not just from Norma Towers is the reason they were utilizing them, because there were a lot of messages from Norma Towers even after they broke up. I'm not so concerned with the content of the text messages, but I do think that it is highly relevant in this case, especially the dates November 24th and 25th. I don't even have any objection to paring it down to just that time frame, just so the jury is aware that there was no 2:30 text message, and in fact there were no text messages until after it stopped at 10 o'clock at night. 9:54, I believe, is the last text that occurs on November 24th of 2010, and then the next one isn't until the following day, November 25th, which is Thanksgiving, at 4 o'clock p.m.
Didn't Lugo testify to that? Is there sworn testimony?
Judge, I don't know if I asked him specifically about the 2:30. I do know that he was cross-examined about it. However, they have attacked Lieutenant Lugo's credibility all throughout his testimony. So obviously, any corroborating testimony as to why he did or did not do something in this investigation is relevant. And Judge, I don't have any objection to paring down some of those text messages or redacting some of the
there's
content.
a lot going all the way back to the
Judge.
6th that's clearly not relevant.
Correct, Judge, but I just want it to be known what, through our time period, that there were no text messages. There's a significant gap, in fact.
It looks like it's 10 on the 24th. The last text message on here was sent
9:54 p.m.
Yes, 9:54.
And then the next one isn't until 4:06 p.m. on the 25th. So clearly there's nothing happening the early morning hours of November 25th of 2010.
That one at 4:06, it indicates was read. He didn't send that. He didn't send another one until 5:35 on the 25th. So there's one sent on the 24th at 9:54, and then there's one sent at 5:35. The 4:06 p.m. it says read, and the context of it, the text of it is Happy Thanksgiving.
And Judge, during the cross-examination, they have criticized the investigation specifically of Lieutenant Lugo of what he did and didn't do. And one of them was, which Mr. Escobar asked him about, was his failure to obtain the text messaging through a search warrant. So that is what makes this relevant. His answer to that on redirect was that there was another source for the text messages, and that is from the phone download.
Right. All right, what's the defense position if this was narrowed down to that specific time frame, last text from Mr. Keetley being on the 24th at 9, let me find it again. I didn't want to write on your...
I have extra copies.
Oh, okay, thanks. That way I can just keep it. So the 24th at 9:54 is the last sent text message from Mr. Keetley's phone. Then on the 25th at 4:06, and that was p.m., 9:54 p.m. On the 25th at 4:06 p.m., he apparently read a text that said Happy Thanksgiving, and a little over an hour later, on the 25th at 5:35, he responded, "You too." So what's the defense position if it was to be narrowed down and if the content was taken out? So if we cleanse it as much as possible, because the Happy Thanksgiving and all that, I agree, may not be relevant of what, but they're arguing that it's the sending and receiving that, and the time frame that's relevant in light of the cross-examination of Lugo.
Here's where I would first argue, Judge,
On the wholesale of them, they're not relevant because they don't tend to prove or disprove a material fact. Now when we're talking about cleansing down, we're now Cloroxing everything by doing the super narrowing down. If we're going to cleanse it down, so to speak, because there are gaps in time, if you look at this, all over the place. 11:13 through 11:14, there's gaps. 11:15 to 11:18, there's gaps. 11:19 to 11:20, there's a 24-hour gap. So there are gaps all over the place. So now to come in and say, well, we've got a gap in time from 11:24 to 11:25, and to make it, well, there's something, bad going on here when these horrible murders took place at or sometime around 2, well, we know 911 was called at 2:22 in the morning, sometime prior to that. Well, that's not fair either, because there are lots of gaps. So if we're going to go there, well, we want to be able to show those gaps. Now, if we want to talk about narrow it down, Norma Jean Towers, well, we think those are fair game because she was here to testify. She testified to some of those, some of her text messages, and I think some of these would go to her because, bluntly, they talk about her relationship. She talked about they were just friends, and clearly from some of these text messages, they were actually friends with benefits, according to a number of these text messages. Some of these text messages go on, and
Well, she was crossed on that, and I think she, without saying as much, admitted to some degree. I think that's what she was crossed about. In text messages, you were begging him, to come back to you or something along those lines.
Well,
she hesitated and then answered.
What she said was it ended in September, but we can clearly see that her wanting to get back to Mr. Keetley extended through November, including November 27th, begging to get back with him. And you can see this. So if we're going to go there, I think everything with Norma Jean Towers is appropriate. I don't know who these other people are. I would argue hearsay besides relevancy as far as these other text messages go. I think, I don't know who this Leslie person is on November 6th. I think all of those need to come out as relevancy as well as hearsay. But I think from, if we're going there, I think everything relating to Norma Jean Towers from the 8th.
Judge, I'm fine with that. I'm fine with leaving all of her text messages in. That's fine. I'm fine with the content.
Well, and I mean, the fact that he didn't text after 9:54, isn't that the time? 9:50. That's 10 o'clock at night on the night before Thanksgiving, and the crime that occurred. I mean, that can be argued certainly that he was sleeping. I mean, if you check my phone, there's no text after 10 o'clock because I'm sleeping.
To make it easier for the state, what we can do is that leave this like it is, and then everybody who's not Norma Jean Towers just redact out the substance of the text that's not Norma Jean Towers, so then that way they can have the date and time.
Oh, okay.
That's fine, Judge.
Okay, is that fair?
It's good with me. You all agree. I don't want to stand in the way of progress. Anything you all can agree on, I'm agreeable. I mean, within reason.
That's fine, Judge. I like that.
If you agreed to hang a disco ball from the ceiling, I don't think that I would go along with that. But
I do like sparkly.
I can do some moves, Your Honor, if you want.
only if
I've
we
got
can
the
do
moves
it
like
during
Jaguar.
Mr. Escobar's closing.
Do you want me to? Okay, I will. Judge, I don't have any objection, because he's right. I think we're going to put redacted text so the jury just knows that we've taken stuff
That's
out.
fine. So you just repeat that phrase, redacted text, where you take out anything.
Yes, sir.
Okay. All right. Well, that resolves the text. Anything else?
I think that was it on the text, so.
Judge Pomponio's present. You want to come up, Judge Pomponio, and help out?
When you were talking about disco balls, in the day.
I think you went to school with Mr. Escobar, didn't you?
We used to take disco dance classes.
Uh-oh.
Now she's saying this on camera, right? They're looking at it.
That was you won't say how many years ago.
Were there intermixed with that disco? Were there lessons on cross-examination?
We also were tennis partners.
That's right, we were tennis partners.
Oh boy.
Every day was Wimbledon then.
Judge, I think the last issue was the photographs 126A and B, the handcuffs and flashlight that were found in the defendant's bedroom.
You want to get those in. Through who?
Judge, they were already identified by crime scene investigator Brando.
So were they moved in and they were objected to?
They were
or
not.
They just weren't moved in?
Well, the defense objected, and they were citing to the first trial where they were pulled out, but it's not explained why they were pulled out. We have looked, we cannot find any motion in limine that it addresses these. It's not clear.
What's
from
the
first
relevance of them?
The relevance, Judge, is that it's consistent with him, with his uniform from the Halloween. They were found in his bedroom. It's consistent with how he dressed, according to multiple victims, looking like a law enforcement officer.
Well, but there's any testimony from any of those multiple victims that described many details, including the nature of his shoes, that said that they saw handcuffs or a flashlight?
No, Your Honor. And Judge, according to David Beckwith, the defendant was trying to get the uniform to look like a police officer, and their whole idea was that they were going to dress like law enforcement officers and go in and kill the people that brought him.
Well, but if for some reason he didn't use it, there's no testimony that he had a flashlight or handcuffs on that evening, even if that was part of the plan, but then he didn't use it, I'm hard-pressed to find that it's relevant. If someone had testified he had handcuffs on him, and lo and behold, you found handcuffs in his bedroom, then absolutely, by all means, that picture comes in. But there's no testimony of that. He was dressed, he had a shirt that said security on the back and police or sheriff? Sheriff on the front. He had boots that looked like law enforcement, dark clothes, but there's just no testimony about him having handcuffs or a flashlight. I think the testimony is whoever it was had their hands full with the gun that they were using both hands on. So where would the flashlight even be? And what would be the relevance if there was a flashlight in his car that wasn't used? I mean, I understand that goes to your ID of him, but if there's no one who says he had it, I'm sorry, I don't find it relevant.
Well, it is a small flashlight, Judge. It could have been in his camo.
But so what? Okay. So, but why is that relevant? If it's hidden in his pocket and nobody saw it, how does that add to the identification of him?
It goes along with what his plan was all along, is to impersonate a law enforcement officer and attack the victims who he thought had robbed him.
You've got pictures of the boots, right, that are in the law enforcement, the black boots.
Yes.
And I remember a picture from the scene of an imprint of a boot. Was that ever connected? Was there any comparison of the boot that was recovered from his home and the print at the scene?
No, Judge.
No, Judge, there wasn't any, that was from the side of the porch, and there wasn't any indication that he had ever gone anywhere in that area, just straight to the porch and off, and that was I believe it was found to the right of the home.
All right.
I was just going to add briefly, Your Honor, that neither the handcuffs nor the flashlight were ever even impounded into evidence, so I would argue even more so that the investigators themselves didn't find it relevant enough to impound into evidence, and therefore it shouldn't be found relevant in court either.
Well, I think your theory and theme in this case is that the investigators made several mistakes, right? So this time they didn't make a mistake. They were right that they weren't relevant?
Well, in this case, yeah, these things were not relevant. I mean, if this was the theme that they were looking for, anything law
Is it your
enforcement
position that's the only thing they were right about?
That would have to defer to Mr. Escobar because he had Lieutenant Lugo, but in this case, this was done correctly and it was not found to be relevant.
Well, I don't know that I understand, I appreciate that, but I don't know that would be a reason for me to find that it's not relevant if I thought that it was relevant. But maybe we were both on the same wavelength when they didn't collect it, and based on what I've heard, I don't think that it's relevant. So that's my ruling, that it's not relevant, but not because the law enforcement didn't impound it.
It was just an addition.
All right. And I appreciate it. But no, without someone saying they even, saw what looked like handcuffs or thought he had a flashlight, any of that, I would have let it in. But there's just no testimony about him having it, so I don't find it relevant.
Yes,
And if it was, it would be highly prejudicial. It would outweigh any probative value.
Yes, Your Honor. One thing that we did want to address also is there were many shell casings and projectiles and bullets that we did not open up the envelopes, but we talked to the clerk and she was going to get clear plastic bags to be able to at least display those. So
I don't see any problem with that. I mean, they're in evidence. They were entered into evidence, and if the envelopes weren't opened, or even the ones that were opened, the clerk has indicated that she can put those in a plastic bag and attach the plastic bag to the original envelope, and then it'll have the evidence tag somewhere on it. Is there any objection from the defense as to that?
No objection, Your Honor. I've spoken to her about that.
Yeah, I don't have a problem with that. It's simply putting them out of the actual evidence package and into a plastic bag, and the clerk has indicated that she has the ability to do that.
Yes, Your Honor.
And that's better than having them opening them up and taking them out and touching them. So, it's not biohazard evidence, but it's something that I don't think they need to handle.
One of them is
It may be.
the
It may be.
projectiles are.
Oh. Yeah, you're right. I was thinking of shell casings, but you're right. The projectiles would be biohazardous, so that's even more of a reason to do that. We also provide gloves to them. I mean, unfortunately, there's no, specific instructions to them in handling evidence, but we try to contain things like weapons and things like that so that they can't actually touch them. So I think that this is in keeping with that. But we also provide gloves back there if they're concerned about touching anything. Anything else?
Judge, I think that is it unless defense has anything.
So you expect me to give you the rest of the day off?
Judge, I think we're all going to be working.
I have no doubt. All right, well, thank you all. It was a pleasure, and I'll see you all tomorrow morning at 9 a.m.
Is the bailiff, is the deputy going to contact the juror and say we're starting at 9 if he's able to make it tomorrow?
Yeah, we'll do that, or my JA will. But we have his phone number, and we will definitely let him know that we delayed the proceedings until tomorrow to see if he could make it tomorrow at 9.